All right, hello everybody. My name is Justin Stivers. I am the owner of the probate law firm. We're as you could guess, a probate law firm based out of Miami, Florida, but we're active in almost every county throughout the state of Florida. We do exclusively probate work. I don't do any title, real estate, anything like that. It's specifically probate. That's okay if you're not even sure what probate is. This course is meant to be short and sweet, just very basic. I've been doing this presentation for a while now. I do teach it for credit. This one is not for credit though. This is, a more condensed version, 45 minutes or so. And so the goal of this course is really to, explain what probate is, talk a little bit about, we're going to start with talking about some just key definitions, what some of the main terms are that I think you all as realtors need to know. We're going to talk about how to identify when a property needs to go through probate, when probate might be necessary. We're going to talk a little bit about if it's determined that probate is in fact necessary, what do you need to know so that when you go to your listing presentation or you go to your prospective client, what can you tell him or her so that you really stand out from your competition? There's, as of right now, 90 realtors on this call. But in South Florida, I think there's something like 55,000 or some ridiculous amount of realtors. So there's a ton of competition out there. I think when you're competing for a probate listing, if you have dealt with probate before, or if you're at least able to explain to them a little bit about the process, you're going to stand out from a lot of your competition. And then we'll talk about just briefly a couple of ideas of how you can maybe market for and try to find probate listings, because at the end of the day, most of you all probably prefer working on the listing side as opposed to the buyer side. So how can you, try to find some listings? So that's a little bit about us. Just real quick, so our website is just probatefirm.com. My email is justin@probatefirm.com. So if you have any questions, very accessible as well. And so then again, why I started doing this course, if you're in South Florida, really in Florida in general, normally if this was an in-person seminar, I'd probably go around the room and say, hey, how many of you all have ever dealt with probate? And most people would raise their hands, have gone through it either on the professional level or maybe even on a personal level. Hard to do with 91 people, and definitely wouldn't be super efficient, over Zoom. But most, Florida is a popular place, obviously, for people to retire in. A lot of people moving from the Northeast, really everywhere. I think I saw a stat yesterday or something. There's like 1,000 new people moving to Florida every day or something like that. So crazy. So chances are, an aging population, people live here, they pass away here, and then their kids generally need to sell their property. And so that's kind of, I think there's a need for it. I think there's a market for it. So there's a lot of opportunity for you all as realtors, and I think it's good to be prepared and be knowledgeable about the process. So let's just get started then. So I'm just gonna, this is maybe the least exciting, if any of it's super exciting, but talking about definitions, what is probate? Probate occurs after somebody has died. So in order for there to be what's called probate, that means somebody has to have passed away. And in your world, what that means is someone has died and they left a piece of real estate and it was only in their name. And in order for that property to be sold, in order for that property to eventually be purchased, really for that property to be rented even, we have to go to the court. We have to go through this entire process, which is called probate. And at the end of the process, the judge is going to say who the new owners are. And then we're going to be able to transfer the property to those new owners. And then you, the realtor, can sell it. Or if you're representing the buyer, then you can help the buyer purchase the property. So whenever you hear the word probate, unfortunately, it means that somebody has died, has passed away. And it's a court process. We're going to talk about how to avoid probate as well. And not in every instance is probate necessary. But most of the time, if someone has passed away, it's probably going to be necessary. But we're going to talk a little bit about that. Decedent, that's just what we call somebody who's passed away. And I'll in that email that I send you all after, I'll send you some of these notes as well, so you have them. But decedent just means somebody who's passed away. An estate, E-S-T-A-T-E, estate. When you hear that term, really what that means is when someone's alive, they own. So let's say John Smith is alive, and John has his house, his car, money in a bank, his shoes, whatever else he has. We've got John Smith. That's all the stuff he had. When he dies, we refer to him as the estate of John Smith. And so the estate just means all of the things that the person had, including any debts. So if he owed money to Visa, American Express, Baptist Hospital, whatever, we're also going to call that his estate. Last will and testament, we'll talk a little bit about that. You all are probably familiar with what a will is or what a last will and testament. Very simple. It's a piece of paper that someone does while they're alive, saying who gets what of your stuff after you pass away. Probably the most important term for you all to know is the personal representative. Okay, the personal representative is, some states use the term executor. New York, for example, uses the term executor. In Florida, we use the term personal representative. And excuse me, that's the person who is authorized by the court to hire the realtor, to sell the property, to sign any as-is contracts, to sign, I think I said listing agreement. So it's really, really important for you all to know, and I'm coming at this presentation from the perspective that you all are wanting to represent the seller. So if you're wanting to represent the seller, you need to make sure that you will ultimately work with the personal representative. So I'll talk a little bit more about that in general, but I guess now's as good a place as any. Is the personal representative is appointed by the court. So a lot of times you might be speaking with a daughter of the person who passed away, and the daughter says, Justin, I'm the personal representative. Well, until she gets a piece of paper from the court, and really that's my job, or the probate attorney who's doing that, until she gets that piece of paper, it's called order appointing personal representative, order appointing personal representative. Until you get that, she's not actually the representative. So that's big picture. I just want you all to know that, because as we go through this, you want to make sure that you're working with that person. So just keep that in the back of your mind, and we'll talk about that a little bit more as we go. And then the last term I'm going to mention is beneficiary, and you all probably know what that means. The beneficiary is just who is going to inherit something. So who's going to receive that house? Who's the beneficiary of the stuff of the person who passed away? Okay, so that's the more or less the definition. So how do you know if a property has to go through probate? Like I said a little bit earlier, not every just because someone passed away and they own a piece of property doesn't mean that it goes through probate, but a lot of the time it does. And so your job, I would suggest, is before you, on any deal really, right? One of the first things that you all are probably going to do is someone calls you and say, hey, I want to sell my house at 123 Main Street. Probably one of the first things you're going to do is you're going to go to the tax roll, you're going to go to the property appraiser's website, and you're going to do a little bit of searching to find out if that person you're speaking with is actually the owner. You want to do, you want to find out about the property, do a little bit of research on the property. And that's the same way that I would recommend how to figure out whether or not a property is going to go through probate. So obviously if you speak with someone and they say, hey, my dad just passed away, we want to sell his property, that would maybe get you thinking probate might be necessary. But if someone doesn't tell you that, then we're going to look at the property appraiser's website. So what I'm going to do real quick is I'm just going to share my screen and go through a couple examples to give you an idea of what we're going to look for. Okay, so this is just a sample. Someone passes away. You go and you look at this is Miami-Dade. I know some of you all might work mostly in Broward and different counties, but it's the same thing. You'll see here's the property address, and then under here, under owner, you're going to see, well, that doesn't help, Maria Pichardo, and then EST of after that person's name, right? So right here, Maria Pichardo, EST of. Whenever, you could probably take a guess, that EST stands for estate of. Whenever you see that after somebody's name on the tax roll, on the county's website, anything like that, it's probably a 99.9% chance that property has to go through probate, through that court process before the property could get sold. So if you're doing some research and you're looking, and you come across a property and it's got that EST of after it, like I said, 99.9% chance probate has to happen. Now, probate might already be started, okay? And your client might tell you that, but chances are, if you see that, probate hasn't been started. Now, I get asked a lot, well, when does that EST, when does that estate of get put onto, when does the county update that? Vital Statistics is the government agency in Florida that records death certificate. They say that when someone dies, they notify the county where the person was living, and then the county will update the records and show that and show that the person passed excuse me, passed away, and add that EST up. However, I've seen instances where somebody died 2, 3, 4, 5 years ago, and that EST of is still not on there. So I can't tell you 100% that if you don't see that, it doesn't mean the person passed away. But most of the times you will. Another thing that happens is, you all are probably familiar with Homestead Exemption and homestead tax. If not, Homestead in Florida, what that means is if you have your primary residence, you get essentially you get a lower tax, a lower property tax. You get a tax exemption on your property taxes. Well, when someone, and let me see. So, she getting it? Yeah, so when someone, but here we go, Homestead. So she was getting in 2017, it looks like she was getting the Homestead exemption. But when someone dies, okay, when someone passes away, and the county knows that, they remove the homestead exemption. So a lot of times what happens is, let's say mother and daughter are living in the same house, okay, but the house is just in mom's name. Mom dies. Daughter goes to the county and says, hey, I want to get the property. My mom died. I'm her only child. I want to put the property in my name. The county most likely is going to say, sorry for your loss. You need to go through probate, and we're going to take away your homestead exemption because the property is no longer, because your mom's no longer living. And that's what happened here. Most likely is, I think she passed away in end of 2017 or 2018. And the daughter goes in to get the property in her name, and they remove the exemption in 2018. So I'm not telling you shouldn't notify the county if someone passed away, because that would probably be homestead fraud, but that's what happens a lot of times, and that's sometimes how the county will update this. So that's just a little bit of background. But like I said, this is probably the most common thing that you'll see to know whether or not probate is necessary, when you're looking at the property appraiser's website and you see that EST of. Okay, next example. So here, same sort of thing. We've got two owners, all right? You've got Jesus Silva, EST of, and you've got Maida Silva. So we just talked about, we just talked a little bit about when you see that EST of, that's a pretty good, clear indication that probate's going to be necessary, and that's what happened here. However, what happened in this case is, for whatever reason, Jesus was father, Maida is the daughter. Jesus was not married. Maida's the only daughter. Maida was already on title. So when Jesus passed away, she thought that she inherited the property outright and she was going to be the owner of the property. She gets a realtor. They go through the entire process. They go under contract. They go to closing, and the title company says, "Well, I'm sorry, but did you do a probate for Jesus?" And she says no. And then then she had to go through the probate process, and she's obviously upset because they wasted all this time. And we'll talk about length of time of probate and all of that. But so my guess is, they just didn't realize, someone didn't look at the title. They might have seen this. They just assumed that Maida inherited the property because she was the only daughter and she was already on title. And that unfortunately was not the case. So this happens a lot. This actually happens a fair amount in Miami, but in South Florida in general, where people will own title together, brothers and sisters, maybe investment partners, or something like that. And we're going to talk about tenants and right of survivorship and all of that. But a lot of the times, if you just own the property together and you don't have any special language on the deed itself, that means when somebody dies, that 50%, like in this case, Jesus died and his 50% stayed with him, and Maida only owned 50% of the house. So when she went to sell the property, she only owned 50% of the house, and obviously you can't sell 50% of the house. So she had to do the probate for Jesus. And so it's just pretty common, again, in Miami, where you've got owners and you've got these deeds. Sometimes they're done by the clients themselves. They, just pull a template, or for whatever reason, I see a lot of really bad deeds, and it will just say, Jesus and Maida, Jesus a single man, Maida a single woman, and that's it. And so when one of them dies, then probate ends up having to be necessary. Now, how could they have avoided that, right? So a couple ways. The easiest way to avoid probate, one of the easiest ways, is putting specific language on the deed itself, all right? And I mentioned joint tenants with right of survivorship. And so that's an easy designation that you're going to put on the title itself. It's going to say, something similar to Jesus Silva, a single man, Maida Silva, a single woman, with joint tenants and right of survivorship, joint tenants of right of survivorship. Okay, what that means is, if Jesus had died, when Jesus died, if that language had been on there, it means that his 50% would have automatically gone to Maida, and she would not have had to have done the probate process for Jesus, because she would have automatically become 100% owner of the property, or vice versa. If Maida had died and Jesus was still alive, then she would have become the sole owner of the property, and he would have become sole owner of the property and would not have had to have done a probate. So that's an easy way. If you put joint tenants with right of survivorship, a very easy way to avoid probate. There's a couple other deeds that you can do. I probably don't have time to go too deep into them, but two of them are, one is called a life estate deed, and one of them is called an enhanced life estate deed. The enhanced life estate deed is kind of commonly referred to as a ladybird deed. And what those mean are, the idea is, you own the property. So, Justin Stivers owns a property, and then maybe I want, a cousin to inherit the property after I pass away. So the deed would be written in a way where I own the property when I'm alive, and then when I pass away, it goes to a cousin. So if the deed has special language or certain language on there, you can avoid probate. Probably that's going to be done by the title company, the closing company, the real estate attorney, or after the fact. Probate estate planning attorney can prepare those deeds as well. If you have certain language on that deed, you can avoid probate. I mentioned a will, so a last will and testament. Having a will does not avoid probate. And so that's a big misconception. A lot of times people will do a last will and testament, and they'll say, I, John Smith, want my daughter, Sarah Smith, to receive my property at 123 Main Street when I die. But the property is only in John Smith's name. Okay, he has a will, it's a valid will, it was drafted by an attorney, everything looks good. He says he wants his daughter Sarah to get the property. However, if and when John dies and Sarah has a copy of that will and she goes to the county and says, look, my dad John died, he left me the property, here's a copy of the will. The county is going to say, again, sorry for your loss, but you need to hire a probate attorney and go through the probate process. So wills are good for some reasons. There's a reason for them, but they do not avoid probate. And so, I can't tell you how many people come to us after their parents pass away or somebody dies, and they're, frustrated because they're like, well, my parents did a will. Why do I have to spend money now and go to court and do all of that? And, my answer is, well, it's just, I do the laws. I don't make the laws, but that's just kind of the way it is. So, having a will does not avoid probate. So if you get a client or a potential client and they say, look, here's my mom's will, she says I get the property, that doesn't mean you get to all of a sudden go list the property and try to sell it. You would have the same problems that you ran into here, where if you go to closing and you try to show the closing agent, look, here's a copy of my client's will, they're going to say, well, you still need to do a probate. So one more thing that will avoid probate, and this is my last example here, is setting up a trust. Okay, and so I always get a ton of questions about trust, and if we have time, we'll talk a little bit about them. A trust, when done properly, does avoid probate. Okay, so it's similar in some ways to a will, in the sense that a trust is a piece of paper that we're going to draft, and it's going to say who gets what of your stuff, right? So in this case, for real estate, I, Justin Stivers, am going to create a trust, and I'm going to say I want my cousin to receive my property at 123 Main Street when I die. Okay, that's step number one. Step number two, though, is I actually have to update the deed. So let's see. Okay, so this property was originally, purchased in, I think 2002 or 2001, whatever the original owner was. It was originally only in Karen S. Rodman's name. Okay, she owned it individually. Karen S. Rodman owned the property. At some point, she did a trust. Okay, that's step number one. But then she had to go and do another deed, and she had to transfer the property from herself to the trust. So right here, the TRS stands for trust. So right now, this property is owned by the Karen S. Rodman Trust, which means that when Karen S. Rodman passes away, the property automatically goes to her beneficiary, automatically goes to the person who she left the property to in her trust, and that person will not have to go through probate. So creating a trust, very useful. A lot of times people are hesitant to do a trust because, yes, they cost a little bit more than a will. No, they're not only for the rich and famous and for people with, billions of dollars in offshore accounts. If you have one piece of property, depending on your situation, it may make sense to put the property into a trust if you're concerned with your family or whoever you're leaving the property to, avoiding probate, right? So again, two-step process. You create the trust document itself, and then we're going to transfer the property to the name of the trust and make the trust the owner of the property. So again, these are just, examples. If you see that EST of, pretty much means it's going to go through probate. Just because two people are on title and only one of them has died, doesn't mean that the other person who's alive is still on title is going to receive the property. We're going to want to look at the deed. If it's got certain language on there, joint tenants with right of survivorship, a life estate deed, a ladybird deed, it can avoid probate. Or also, if it's a trust, then it can also avoid probate as well. Husband and wife also going to avoid probate if they're both on title. Okay, so the general rule is, if you've got husband and wife, and so let's say John and Sarah are husband and wife, and it says John and Sarah as husband and wife or it's going to say a married couple on the deed itself. If the husband were to die, the spouse, the wife, automatically inherits the property. She's not going to have to go through probate to get the rest of the property in her name. Or vice versa, if she dies, he wouldn't have to go through probate. The one situation where sometimes that gets a little complicated is some of these older deeds might just say John Smith, a married man, and it doesn't have the spouse on there. I've seen title companies require probate for that if the spouse is not on there. Or also if a lot of times what happens, maybe the husband or the wife purchased a property before the marriage, right? So John bought a house, 10 years before he got married, kept it as an investment property, never updated the deed, never put his wife on the deed. That property, in order for that spouse to get that property, she's probably going to have to do a probate for him. So it happens, in a perfect world, usually when husband and wife, or, they purchase a property, they're both going to be on title as husband and wife, and probate wouldn't be necessary. But there are some times when it's necessary. So, all right, I'm going to stop the share there. I'm going to scroll. I know there's probably some questions I couldn't see while I was talking. Let's see which ones I want to answer. I'll answer this one real quick. So what if the property is under an LLC? So an LLC, that's a good question. We see a lot of that in South Florida, a lot of investors. Generally, yes, you're going to have to do for probate if the property is in an LLC. And so a lot of times what happens is you got an investor from, Haiti, Venezuela, Argentina, wherever. They buy a piece of property, and for tax purposes, they put the property in an LLC. Makes sense, perfect strategy, nothing wrong with that. But they don't do an operating agreement, or they don't put anything in writing as to what happens if the owner of the LLC passes away. So when, the owner of the LLC dies, his family in Argentina, they don't automatically get the property. They're going to have to do a probate for him in order to get the property put in their name. So what I generally recommend to, foreign investors is an LLC is great, perfect, no issue there. You get the tax benefits, you get, liability protection and all of that. What you might want to do is either two things. Either one, we do an operating agreement that says what happens if the owner of the LLC passes away, or maybe, and in addition to that, we do a trust and we put the LLC in the trust so that the trust owns the LLC. I know that might be a little bit complicated, but that way then the trust is going to say what happens to the owner of the LLC, and then we can transfer it. So that's really common. I see a lot of that with LLCs because, again, it costs like, $110 or whatever on Sunbiz to create an LLC. So people, purchase properties in LLCs, which, again, I think they're perfect to do. They're fine to do. But in terms of avoiding probate, not going to avoid probate just in themselves. All right, cool. So let's shift gears a little bit. So let me see. So let's say that we've determined that probate is necessary, right? And so again, I say you're probably, it's not necessary, I don't want you all doing anything close to practicing law unless you're an attorney, but, so you're kind of just figuring out, gathering some information. Maybe this client already has an attorney, or maybe you're in a position to make a recommendation, either or. Let's say though, regardless, we figured out that probate's necessary. The attorney said it's necessary, you figured it out. Okay. So like I said a little bit ago, we want to make sure that you all are working with the personal representative, right? Because the personal representative, or what I'm going to maybe say from here on out, is going to be called a PR. That's kind of the short language PR, personal representative. We want to make sure that you're working with the PR, because if not, if you're working, let's say that there's two brothers, and you're working with brother number one, and brother number one says, hey, Justin, I want to use you as my realtor. And you're like, great, let's do this. Let's sign a listing agreement. Let's go forward. But then we find out that brother number 2 was named in the will and he's going to be the PR. Well, now, and let's say brother number 1 and brother number 2 do not like each other. Well, now brother number 2 gets to pick the PR, and you wasted all your time speaking with brother number 1, because if they don't like each other, chances are they're not going to pick the same realtor, right? So from the very beginning, we want to, I want to make sure that you all are protected and that you're working with the person who is actually going to become the PR. So because remember what I said is the person who becomes PR has to be named by the court. It's actually a piece of paper that's going to say who the PR is. So how do we figure that out? Well, I'm generally going to recommend 2 questions. One of them is a 2-part question when you go to do your listing presentation. We're probably going to want to ask first, is the person who died, did they have a will? All right. And the reason we're going to ask that is because I've never seen a will that doesn't name the PR. Maybe it's possible, but most every single will that's done names who they want to be their PR, their personal representative. So if there is a will, right? So if there is a will, we're going to want to look at a copy of it and see if the person you're speaking with is named as the PR. Because if they're not, we're speaking with the wrong person, right? So we want to ask him, we want to find out if there is a will, and we want to make sure it's a valid will. And again, that's kind of my job. So I'll just give you a quick story if I can. So had a case where our client had a will from the grandmother that was done in, let's just say 1990, okay? And it named my client as the PR. There was a second will that was done about 15 years later, that named her uncle as the PR, okay? So we've got 2 wills. One will names my client as the PR. The second will names her uncle as the PR, okay? Normally, people do second wills all the time, that's fine. Normally, that second will would be valid, right? And the uncle would end up being the personal representative. So if you had been speaking with my client and you just assumed her will was valid and she named you and she wants to hire you, you might be in trouble. But what happened is we had to go to court, and we argued that when that second will was done, the person who died, the grandmother, had Alzheimer's when she created that second will. And so we brought doctors in and everything, and the judge found that, yeah, she did have Alzheimer's when she signed that second will in 2015, or 15 years later. And so she got rid of that will. And so my client ended up being the representative. And so the reason hopefully that's not too confusing, but the reason I share that story is because just because someone shows you a will and says, hey, look, this is my dad's will, they name me as the representative, know that until we go to court and get that will proved, there could be a second or a third will out there. And so a lot of times I'll get a call from a realtor, excuse me, or from somebody, and they'll say, look, I'm ready to go. I've got my representative here. And I say, well, did we go to court yet? Do we have that order appointing personal representative? Because if we don't, let's not jump the gun just yet. So anyways, first question we want to ask, is there a will? And the second thing we want to ask is, do they have a copy of it? Okay, and the reason we want to ask if they have a copy of it, wills they're not really recorded. There's not like a master database where I or any attorney can just go and search www.will.com and find out if somebody had a will. And I had this call yesterday. Hey, my mom died. I think she left a will, but I can't find it. Well, a will is just a piece of paper, right? So if I do a will right now and I put it in my desk drawer and I don't tell anybody that I had it, nobody's going to know that I had a will, right? It's not going to go to court most of the time. So if somebody tells you, hey, my dad had a will, but I can't find it, there's nothing we can do, really. So ask them if they have a will, ask them if they have a copy of it. The second, that's part one and part 1A. The second question I want to ask is, what's your relationship to the person who passed away? Was this your mom? Was this your dad? Was this your brother, sister, uncle? Who was this? Okay. Because in Florida, if there is no will, so a will, like we've been talking about, is probably going to say who the PR is. But if there is no will, which is common, a lot of people don't have wills, Florida has a hierarchy of who gets to be the representative. First, it's going to be the spouse, if there's a surviving spouse. Then it's going to be the children. Then it's going to be the parents. Then it's the brothers and sisters and grandparents, and then on and on and on until you get to like second and third and fourth cousins, right? But most of the time, we don't need to go to like second and third and fourth cousins, because there's going to be a spouse, a child, a parent, a brother, a sister, an aunt or an uncle. And so, but again, in South Florida, it's very common where, uncles maybe, or, cousins may be taking care of his cousin, and they say, hey, yeah, but he had kids, but they all left. They went to California and abandoned him, and they haven't seen him in 50 years or whatever. That doesn't matter. If there's kids and we can't find them, they still have preference. So so again, one of the questions we want to ask is, what's your relationship to the person who passed away? And the closer they are in relationship, the more likely that they're going to be the representative. So a question I get a lot is, well, what happens if there's no will and there's multiple siblings, right? There's multiple kids. Who gets to be the representative? The first answer is, let's say that there's 3 kids, the majority can pick. So if 2 of them choose one, and the third one doesn't agree, whoever the 2 choose, that one would have the preference to be the representative. If they all 3 disagree, like if they all want to be representative, what's probably going to happen is we're going to have to go to court, and the court is going to choose, and likely, unless they all 3 have attorneys, which they probably don't, whoever hired the attorney is most likely going to be the one who gets to be the representative. So if they all can't agree, the court's going to decide, and that's going to be, really a determination by the court based on either the attorney making an argument. The only person who can't be a representative is a minor child, so someone under 18, or a convicted felon. Those are really the only two people who can't be a representative. Doesn't matter if they live out of state. We have a lot of out-of-state personal representatives. Most likely it's not going to be the attorney either. I don't really serve as representative. Normally it's a family member who's going to be the representative. So let's see. Let me just check real quick. See if there's anything relevant I want to. Can a property owned by, this is going back, I'll answer this one. Can a property owned by a trust get the homestead exemption? Yeah. So if your property is your homestead and you put the property in a trust, it can still get the homestead exemption. Is there a time limit to do a probate? No, you can do it whenever. We have one where the person died in like 1950. And his great granddaughter opened the probate because no one else had done it. So there's no time limit. Stepchildren, are they counted for this? It depends. It really depends on were they legally adopted. If they're not legally adopted, then most likely they don't have any rights to anything. They need to be legally adopted, or possibly there's some other types of things we can use, but most of the time they're not. All right. And I talked about wills not avoiding probate. All right, so now we've made kind of a determination who we think is going to be the representative. We're pretty sure that this person is going to be the representative. Now, most likely, this prospective client is going to want to know a little bit about the process, right? How long does the probate process take, et cetera, et cetera. So how long is the probate process going to take? Well, I'm going to give you all 2 different situations, right? So the first situation is the shorter situation. If the person died more than 2 years ago, right? So right now, if the person had died more than 2 years ago and we're opening up the probate right now, most likely it's going to take 30 days to get the representative appointed. All right. So once we get the representative, so 0 to 30 days. Now we've got the representative appointed. After we get the representative appointed, now we can go ahead and sell the property. So most of the time, if the person died more than 2 years ago, I would say on average, it's going to take about 3, maybe 4 months, more or less. That's just a generalization. There's certainly, and you all have probably maybe even experienced some where it took a lot longer than that. But if the person died more than 2 years ago, often it should only take about 3 to 4 months. And the reason is we get the personal representative. Most of the time it takes 30 to 45 days to get the representative appointed. Once that PR has been appointed, now you all are free to list and to sell the property. Okay. So more than 2 years ago, let's just say 3 to 4 months. If the person died more recently, so if the person died within 2 years, and now we're opening up the probate, it's still going to take us 30 to 45 days to get the representative appointed, okay? But then there's what's called a creditor period, which doesn't come into play if the person died more than 2 years ago. It's kind of like, you maybe have heard the phrase statute of limitations, but there's a 90-day creditor period that we have to wait if the person died within 2 years. So if the person died within 2 years, more recently, 30 days to get the representative appointed, then we have to wait during month 2, wait during month 3, wait during month 4, and now we can try and sell the property. So if the person died within 2 years, it's likely about I would say 6, maybe 7-month process. It's a little bit longer. And the reason what we're doing during that 90-day creditor period is we're waiting to see if the person who died owed any money to anybody. So did they owe money to Visa, American Express, Baptist Hospital? Any hospital bills and credit card bills are generally the most common thing. And unfortunately, the courts will not let us sell the property during that 90-day window. Now, you might hear stuff out there that will say, well, what if we sell the property and then we put that money into an escrow account until that 90-day period is up? Yes, that's happened sometimes, but very, very rarely, and that's actually contrary to Florida law, and so I would not count on that. Basically, you still are going to have to wait that 90-day period. So if the person died more than 2 years or within 2 years, it's probably going to be about a 6 to 7 month process. That's, again, more or less the average. It can be a little bit shorter, a little bit longer, but that's just, more or less the average. All right. Okay. So when can you all actually list the property, right? And so this is another big one. Really, you all should not be listing the property until the representative has been appointed by the court. Okay, so you should not put this property on the MLS. You should not market the property. You should not put door hangers or signs in yards or anything like that until the representative has been appointed. And I've said it 1,000 times, the representative is appointed by the court. Here's my reason. Here's why I say that. Let's say that you list it, and someone calls you that day and says, "Hey, love that property, love to purchase it. Here's cash offer, close in 30 days." You're excited. You sign the contract. But your client has not been named the PR. Well, remember my scenario a little bit ago where we had 2 wills that named 2 different representatives. Let's say that I go to court and we find out there was another will and somebody else is now going to be the representative. And you just signed a contract on behalf of somebody who doesn't have any authority to sell that property. You could get in trouble. That person could potentially get in trouble. So that's why I always say, let's wait until the representative who gets appointed. And so again, it's called an order appointing personal representative. That's going to be coming from the court. Until you have that piece of paper, I would not list the property. I would not market the property. Once you get that piece of paper, go to town. Right now, once you get that, now you can sell the property. now you can market the property. Now you can list the property. When can you actually close on the property? Well, again, depending on the two different situations, if we have to wait for that creditor period, you can go under contract, and a lot of my clients do. A lot of my clients will still go under contract, but it has to be, the buyer needs to know, hey, listen, this is not a 30-day deal. We need to at least wait that 90-day period. We have to maybe get the sale approved by the court, et cetera, et cetera. You can still go under contract once the representative has been appointed, but you're probably not going to be able to close until that creditor period is up. If it's in that first situation of more than 2 years ago, you can sell the property, you can go under contract and close right after the client's been named as the representative. The contract itself needs to be signed by the representative as the representative. So when you sign that as is contract, let's say that John Smith is the personal representative, he needs to sign that contract, John Smith, as the personal representative. So any document that he's going to sign is going to be signed as the representative. Most likely in the contract as well, we're probably going to put, in that, I think it's like paragraph E, or I don't remember what paragraph, but that little notes section in the as is contract. Depending on what's going on, we might put certain language in there that says subject to court approval, pending probate case number 2020 CP 00465, whatever the case number is. We might put a little bit of language in there. If I'm working on the deal, I might say, hey, just put this language in there, but nothing too crazy. We don't need to have a bunch of addendums and all of that. For the most part, I always say, to the realtors that I'm working with, the deal for the most part is basically like any other deal that you all are going to have. The main difference is we got to wait for the representatives to be appointed. We've got to maybe put simple language in that contract. The contract needs to be signed by the representative. Other than that, everything else is pretty standard. Other than that, everything is pretty much normal. The hardest part on these deals often is, one, we're often at the mercy of the court, which the wheels of justice do not move quickly, so sometimes it takes a little bit of time. Two, we're dealing with clients who are possibly going through a very sensitive situation. Mom's just died, they're selling the family house, so it's just a much more emotional sale for people. Three, we might have fighting siblings, right? And that can certainly complicate the deal. So a lot of the times these deals become complicated, not necessarily from like a legal or, that type of aspect. It's just sometimes they're more emotionally charged, sensitive deals than a lot of other deals. Let me just take a skim here quick. All right, so I answered the document we can request for proof of who was appointed. That's the order appointing personal representative. You're probably going to get that from the attorney. If a probate has been opened, I would ask the attorney handling the deal for a copy of that. Do debtors get paid first? So no, not really. How much time we got? Okay, so homestead property. So we talked about homestead. Homestead properties are exempt from creditors. So let's say that mom dies and she has, a huge Medicaid bill, Medicare bill, Visa bill. She owed a lot of money to a lot of people, but the only asset that she had was her, property in Little Havana. Well, that house or that apartment is exempt from creditors. So you, the realtor, will get to sell the property, and Baptist Health, Visa is not going to get a dime from that sale. Okay, so creditors are the homestead properties are exempt from any creditors. If mom also had, though, $10,000 in a bank account, they could come after that. But the homestead property is exempt. If mom has a homestead property and an investment property, they could potentially go after the investment property. So that's when it becomes very important. We need to know whether or not it's a homestead. We have to have the court sign a document saying that it was the homestead. So if it's a homestead property, debtors aren't going to get anything. Creditors are not going to get anything. If it's an investment property and there are creditors, that could be an issue. After the 90 days creditor period elapses, how long does the court take to approve the sale if it has to? I would say rule of thumb is probably 30 to 45 days. It really depends. After the creditor period is up, we're probably, going to get a hearing as soon as we can, or ideally we've got the hearing set even before that creditor period is up. So as soon as after, but again, courts move slowly. So, but generally I would say 30, 45 days, maybe 60 days, worst case scenario. And what name goes as owner in the contract? It's the representative. It's the personal representative. So John Smith, as the personal representative, is the person who's going to sign the contract. What is LEREM? It's a life estate. So that's talking about a type of deed. So I won't answer that one too much. But what is, and last one I'll answer before I continue is, reverse mortgage started a foreclosure process, or foreclosures in general. So a lot of times these properties go into foreclosure because, there's no one else to pay the mortgage. The kids don't want to pay the mortgage, or can't pay the mortgage, or maybe there's HOA dues or whatnot. Probate is not going to stop the foreclosure. So you can't call the mortgage company and say, listen, mom died. Can we stop the foreclosure? We're going to sell it. We just need some time. It's got to go through the probate process. If it comes to us soon enough, the foreclosure shouldn't be an issue, right? We can delay the foreclosure if we need to for a year probably, or maybe even a little bit longer. But if it's just a general foreclosure, we can still buy enough time so that we can complete the probate so that the property can get sold. Reverse mortgages, still same idea. But maybe, reverse mortgages are a little bit different. They might even give you more time. Sometimes they'll say you have up to a year to sell the property if you need to. Yeah. Okay, so how can you find probate listings? How can you, what are some ways to market for probate listings? There's really a couple ideas that I have that I've seen work relatively well. Probably honestly, the best way is just building relationships with other probate attorneys, right? And that's not self-serving for me. That's really, information for you all, because a lot of times the probate, if a client comes to us, I would say 90%, if not more, of the probates that we handle have a piece of real estate in them. And often the clients want to sell the property, they want to rent the property, they want to get rid of the property. So when I'm able to, if I'm in a position to, I prefer to refer the property out to a realtor that I know, like, and trust, that I know will take care of the client, will do a good job. And so if I can, I like to refer that out. And so I know a lot of other probate attorneys do the same way. So if you can network, listen, attorneys are difficult, they're a pain to deal with a lot of times. But if you can network with them, I know now's a little bit different, but if you can find ways to build relationships with probate attorneys, that's usually a good way. You can also buy lists. So there are companies that will sell probate, listings, that will sell information of who the representative is and who the attorney is. For example, this just came to me a day or two ago, but this is just a letter. You can't really see it, but a letter that came from a realtor, and it just, as a newly appointed personal representative, you may feel though you are facing an unclimbable mountain if you're hoping to find a trusted probate advisor, yada, yada, yada. So here's a letter, right? I don't know how effective these are, but, there are ways. This is actually not a bad one. I've seen some really bad ones. This one is actually, decent. One thing I always recommend is, remember that if you're speaking with, if you're trying to speak with the representative, the one thing I would say, this is a good selling point. I will sell your home in 21 days, or I will waive my commission and sell it for free. Okay, great offer. The thing I would say about that is, if we're selling mom's house and it was like a childhood home and it's very emotional, I'd probably want to add a little bit more sympathy, like, very sorry for your loss, et cetera, something like that. I maybe care a little bit less than, that it's a quick sale. But so anyways, those are some things that you can do. You can get lists, you can go to the courthouse, you can pull public records and try to get listings that way. I think it's a great, like I said, I think this is a great, it's a great niche to get in. I know a couple realtors who have done very well. They advertise themselves as probate realtors, as probate experts in listing probate properties, and that's great. There's not a whole lot of people who really dedicate themselves to this area. So I think there's a lot of opportunity. I see where people are dropping like flies. I know we're about 2 minutes over. I've got another minute or two. I'm just going to scroll up. If you all have any other questions, I can stick around for like another minute or two. If not, what I'll do is, yes, this is being recorded, so I will send you all an email with a link to the recording. If not today, sometime early next week, so you will get a copy of it. Again, my name is Justin Stivers. Our website is probatefirm.com. My email is justin@probatefirm.com. So I don't see any other questions. So thank you guys for tuning in. Hope you guys have a great weekend, and we'll talk to you soon. Take care.